Article 23 is the grievance procedure. Similar to Article 22, this goes into more detail about the actual procedures in filing a grievance and timelines. Now, let me begin with the definition of a grievance. A grievance shall mean any dispute concerning the application or interpretation of the terms of this CBA, contract bargaining agreement. So it's a dispute revolving around the interpretation of the CBA and the terms of the CBA. The grievance procedure is then gone into, under Article 23, looking at timelines and the various steps and going on to alternative dispute resolution. Let me first talk about timelines. For disciplinary matters, which we just touched upon in the previous article, disciplinary grievances, you need to file your grievance within 10 days, and those are working days. So it's very important that anyone who is undergoing some sort of disciplinary nature action will be filing their grievance. Go immediately to the steward and file your grievance and get that in within 10 working days. All other grievances have a 21-day time limit, and those are 21 calendar days. So there's a little bit of a difference there, and you don't want to get tripped up on that. So discipline 10 days, other article disputes 21 days, calendar days. The steps for the grievance procedure are step 1, that takes place at the agency. Step 2, also at the agency, but probably at a regional office. And step 3 takes it outside of the agency and moves it to the domain of the Office of Employee Relations. That's at 1 Ashburton Place in Boston. And it's a slightly more formal hearing at OER. There are time limits between the different step levels. So you have 10 days to move it from step 1 to step 2, and again another 10 days from step 2 decision to step 3. Generally, we follow that carefully, and we work actively to move the grievance along and to prod the administration for making a decision on matters. But a lot is within the control of the administration in terms of timing and decision writing. Step 3 decisions might take several months to come across and be delivered to us. There's also at step 3 an opportunity to call for alternative dispute resolution. Rather than having a formal step 3 hearing, we can the union can only ask to have the case brought for ADR before a third party. Usually there will be a representative from the administration, someone from the union, and an arbitrator who would listen to the case. And I'll leave it to Richard to talk maybe a little bit more about ADR, but those are good ways of moving a case and moving it more quickly through the step 3 process. Arbitration is the 4th step in the process, and arbitration will occur only after the executive board of your local union votes whether or not to arbitrate the case. And each union member has a right to address the executive board and ask for their grievance, their case, to be arbitrated. The executive committee will listen to the grievance side of the story. We'll then look at the evidence that is taking place in the case, and look at the decision from the Office of Employee Relations, and weigh whether or not the grievance is something that should go forward to arbitration. It should be noted that the executive board of this local union takes these things seriously, and we do weigh the evidence, and we do not always arbitrate cases. If the case does not justify arbitration, we do not arbitrate it. And the grievant then has the right of appeal. The appeal goes to the national president and general counsel for review, and the appeal rights are looked at that point by the general counsel of NAGE. So at this point, let me turn things over to David Young to look at the grievance procedure, but from the agency's perspective.
Okay. When I was a management representative, I made up my own number of laws to guide me in my work. And one of those laws is that labor relations is governed by rigidly defined rules of ambiguity. Negotiated language in the collective bargaining agreement cannot address all possible future conditions and events. Management and the union cannot walk away from the bargaining table with exactly the same understanding of the negotiated language. There are injustices visited upon employees in the name of management rights. There is the perennial issue of disciplinary action. Well, how does management and the union maintain stability at the workplace? The answer is the grievance procedure, which in many cases will result in final and binding arbitration on the issue before the arbitrator. The grievance procedure provides a relief valve to labor management disputes and maintains a civilized legal relationship between the parties. As Greg said, the grievance procedure has 4 steps, and this tends to be a long process. It's not an overnight process. That's why often management and labor will be working towards settlement of grievances to get the matter concluded. Even though it's a long process, it's a positive process in terms of fact-finding and clarifying the position of the parties. It's very helpful to have these hearings and get a feel for what the management's case is, and management getting a feel for what the union's case is. This often results in settlement as well. The official grievance forum can be found on the NAGE website. I have seen other versions of the grievance form, and they should be avoided. Also, check in with NAGE to see if you have a valid grievance. Recently, a steward filed a grievance concerning transfer of benefits from one constitutional office to another when state regulations clearly prohibited this transfer, so the grievance had to be withdrawn. However, as to disciplinary grievances, the time frames are very short. 10 work days to get the grievance filed. As mentioned in the discussion of Article 22, don't leave a disciplinary action unaddressed. This is essentially a concession that the management was right and the employee was wrong. Grievances may also be filed by fax or by email. Contact the NAGE office about the filing of a grievance, and we will assess the grievance and also direct you to the proper party for filing the grievance. There is a provision in the collective bargaining agreement for alternative dispute resolution. Richard will be addressing that in more detail. Finally, do not file a grievance just because a member is upset. The grievance procedure is to dispute the application or interpretation of the terms and conditions of the collective bargaining agreement, not as a protest against management. Grievance filed just to protest management's actions will wither and die. and not serve the member or the union well.
Wise words. Richard?
Thank you. There are a couple of things I would like to add to the previous discussion of the grievance process. One is when a member approaches you with respect to filing a grievance, you need to talk to the member, find out what happened, and then you have to make an analysis and find out whether the grievance that the member wants to file actually involves any violation of the collective bargaining agreement. Just as David said, just because a member is unhappy doesn't mean there are grounds to file a grievance. So what you need to do is by talking to the member, find out what happened, and then look at the contract and determine whether the events that occurred actually violate any article of the contract. For example, say a member comes to you and says, my anniversary date is November 1st, and I didn't get my step raise on November 1st, and my EPRSs are all meets. Well, that sounds like a good grievance. If your anniversary date is November 1st, and you would do a step raise and didn't get it, then it's worth filing a grievance to make sure that the member gets that step increase that he or she is due. So, following from that, when you file the grievance, you need to do two things. First, you need to provide a brief description of what happened. In this case, you'd say, Member Jones has an anniversary date of November 1st, and he didn't get his step increase that day. And then you have to go further down on the grievance form and state what articles of the collective bargaining agreement were violated. So you look through the contract and you find the salary article and figure out what part of the salary article is violated. So then you would say, you'd cite the article number and say the actions here violate Article
7.
Whatever the collective bargaining agreement is, and all other relevant articles of the agreement. And then for remedies sought, that's another portion of the grievance form, we need to say the member should be made whole in every way, plus whatever other relief you want. Made whole is a labor relations term that basically means the member should get everything that he or she deserved. That's what make whole means. And then following from that, once you get the grievance filed in the right place, you need to watch the timelines. And those timelines are contained within the grievance article. And they will tell you not only what you need to do when you get an adverse decision, that is moving to the next step within a specified period of time, but also they specify, the article will specify when you can say that you basically have a constructive denial because the grievance has been on file at step 2 and the employer hasn't done anything. The employer hasn't answered you at all. In that case, once the employer has had the grievance in his or her hands for the specified period of time, you can take the employer's failure to respond as a denial of the grievance and move it to the next step. So that means there's a way of keeping grievances moving through the process. In other words, the employer can't stymie the grievance process simply by sitting on a grievance. And that's an important thing to keep in mind when you have a member who was anxious about getting his grievance moved through the process. And it is a lengthy process. With respect to full formal arbitration, it is a somewhat formal process. When a case that you're involved in goes to arbitration, it will be assigned to a union attorney who may well be contacting you, and will certainly be contacting the grievant with respect to getting ready for the arbitration and describing what happens in the arbitration process itself. Arbitration is the fourth and almost always the final step of the grievance process. There are limited circumstances, but very limited circumstances, in which an arbitrator's award can be appealed into the court system. But those are very limited. So don't count on an arbitration decision being appealed into the court system. It's not very likely that will happen. Finally, with respect to ADR, also known as alternative dispute resolution, that's really a mini form of arbitration. Under our collective bargaining agreement, we do have a provision for that, and basically what it comes down to is it's an expedited version of arbitration. Basically, although I don't handle these sorts of cases myself, I can say that a number of cases can be put before the same arbitrator in one day. The parties might have at most an hour or two to present the case. The arbitrators don't take briefs, and that's important because briefs add to the duration of the arbitration process, but in what we call ADR, there's a very brief hearing before the arbitrator. There are no briefs. Each side gets to make its presentation, and then within a very short period of time, the arbitrator issues a very short, maybe one-page written decision resolving the case. And this is useful, doing this form of arbitration is useful in relatively simple cases such as, was a person denied overtime on a particular day or something like that. Because the presentations have to be so short under the ADR rules, ADR is really limited to very straightforward up or down cases where the presentation can be made in a very brief period of time, and there's no need for written briefs to clarify the issues in front of the arbitrator. So if you have what you view as a very straightforward case, such as somebody didn't get the overtime pay that he or she deserved on a particular day, you might want to discuss the possibility of ADR with the union representative or union president. Maybe the case can be sent to ADR and resolved more quickly than it could be in full formal arbitration.
Thank you very much.